Hi, I'm Reed Bloodworth, founding partner of Bloodworth Law. Today, I'm going to talk about what makes a verbal contract legitimate. First, what's a verbal contract? Well, a verbal contract is just like a written contract. It has the same basic elements. It has to be an offer, it has to be an acceptance, there has to be something that you're actually negotiating over of value, and the parties must have the capacity to enter into that contract. If you have those basic elements, you can enter into a verbal contract. There are certain things you may not be able to enter into a certain contract on. These things are governed by the statute of frauds. Some very common ones are real estate transactions. Got to have it in writing. Some other things might be agreements that are going to last longer than 1 year. Need it in writing. However, if you and I entered into a verbal agreement for me to sell you these books for $300, we can negotiate that, enter into that contract, and that would be a binding agreement. Now, these are the types of things that make a verbal agreement enforceable. So there are circumstances which, when people enter into verbal agreements, disputes arise. This is a lot of times because you don't have the writing to go back and say exactly what the agreement was. An example might be a client verbally allows someone else to use their license for a particular project. They agree on it. The client says, all right, I'm going to take 10% of the profit from this project and you will be allowed to use my license. They shake hands. Project goes forward. The person who's using the license, perhaps they pay the 10% on that one project. However, sometime down the road, client discovers that person used my license for many other projects for which I was unaware. And as a result of our agreement, I should get paid on all these other projects. That's a situation where a dispute has arisen and you have a verbal agreement. You might want to bring a lawsuit to enforce that. So, in summary, verbal contract, they are enforceable in certain situations, and in certain situations they're not. They have the same basic requirements as a written agreement. You gotta have an offer, you gotta have acceptance, you gotta have something of value you've negotiated over. You need capacity. When I say capacity, you need to be of age, so over 18, and have your full mental faculties about you. At Bloodworth Law, we represent both plaintiffs and defendants relating to disputes arising from verbal agreements. For plaintiffs, we offer multiple payment options, have contingency fee options, pay-by-the-hour options, and hybrid options. For defendants, we have pay-by-the-hour options and flat fee options. So if you have any questions or you're involved in a dispute pertaining to verbal agreements, verbal contracts, give me a call. Let's talk about what happened to you.